Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. You know, folks, the date, of course, November 13th, 2023, we're coming up on, 2022. We're coming up on 2 years since these murders took place. The Idaho 4, of course, the young kids you see up on the screen, Ethan Chapin, Madison Mogan, Zana Knodel, and Kaylee Gonsalves. That happened November 13th. So this Wednesday, I believe, is 2 years. So all of these court appearances, we've already had the case moved from Latah County, Idaho, the town of Moscow, where the University of Idaho is. And we had the case moved to Boise, Idaho, at the request of the defense. So now the next thing the defense is trying to do, of course, is they're trying to get the death penalty thrown off the table, not to be considered. And we're going to discuss today some of their arguments, some of the arguments they set forth to do that. It does not seem in this case that the judge was overly impressed with their arguments. Judge Stephen Hippler. I mean, just look at the thumbnail of him on the screen. He doesn't look like he puts up with much nonsense. He asks you to pass the potatoes at dinner, you better pass the potatoes. I don't know why I use that analogy, but he didn't seem too impressed with the arguments presented on Thursday by the defense. Anyway, folks, hold on to your hats, hold on to your seats, hold on to your wig, your toupee, your glasses. You're about to enter true crime from a police perspective. You're about to enter the off-the-cuff zone, the police off-the-cuff zone.
There has to be some common sense.
They were the ones who called 911 to get him help, and now they're calling for change.
Before we start the show, first, a word from our sponsor. BetOnline is the world's most trusted betting platform and your number one source for online betting. From the earliest odds to in-game live betting, BetOnline provides you with all the action and the ability to watch the games as they happen. With the largest selection of odds on everything from football, NBA and college basketball, NHL to UFC and MMA. Head to BetOnline today to get in on the action with America's most trusted site for online wagering. BetOnline, the game starts here. Joining me tonight is retired NYPD Sergeant, professor at Albertus Magnus College in Connecticut, and attorney. Welcome to the show, Professor Mike Geary. Mike, welcome.
Hey, good evening, Bill. Good to see you. Good to see you. Thank you for having me on. This will be great.
Yeah, it should be excellent. You know, Mike, I just think that, with the change of venue and all the different things that are going on in this case, I think they almost needed a no-nonsense judge, because it seemed like Judge John Judge, who was the Latah County judge, he seemed like he bent over backwards to please the defense and to rule in the defense's perspective and the defense's point of view. And I think that Ann Taylor, who's the lead attorney here, I think she was used to it somewhat, getting her way with Judge John Judge, because Ann Taylor is no stranger. She's no rookie. She was at one time a Latah County district attorney. She worked for this man, right? Mr. Thompson. And so she's not a new jack. She's not, by no means is she a new jack. But having said that, she has to also cross her T's and dot her I's because she's coming up in front of a no-nonsense judge who also, I believe, knows his stuff. Kohberger is facing 4 counts of first-degree murder and 1 count of felony burglary. He's accused of fatally stabbing University of Idaho students Madison Mogen, Kaylee Gonsalves, Zana Knodel, and Ethan Chapin in an off-campus residence in 2022. Of course, that's in Moscow, Idaho. Kohberger could face the death penalty if convicted. The defense has objected to the state's intention to seek the death penalty in a series of motions. The prosecution and defense presented their arguments to District Judge Stephen Hippler on Thursday. After listening to both sides, Hippler said he would take the matter under advisement and issue a ruling at a later date. Ann Taylor, Kohberger's lawyer, argued that sitting on death row for decades without knowledge of or how it will be executed could induce anxiety. I'm sure that if I was the judge, that wouldn't be one of my number one problems, worrying about the defendant's anxiety after he's accused of murdering 4 college students. That would not really cross my plate as an important thing, that I'm worried about the defendant's anxiety awaiting the death penalty. Your thoughts, Mike?
Yeah, Billy, the whole thrust of the defense's motion here is that the death penalty is cruel and unusual, no matter how you do it, when you do it, how you do it, how long it takes, whatever method it is, it's all cruel and unusual. And part of the cruelty and the unusualness of it is that a person may, while they're appealing their death sentence, sit on death row for many, many years, and that could produce anxiety. And that kind of anxiety, not knowing when or how you're going to be put to death, creates a situation that is cruel and unusual for the defendant, and therefore it's not the kind of punishment that a defendant should get. They should get their punishment and not have to wait an inordinate amount of time, because the waiting period itself produces so much anxiety that it is cruel to them. It sounds like a facetious argument to me, but Ann Taylor has to zealously advocate for her client. He doesn't have a great case. She's doing the best she can, but that's what it's all about. Is this death penalty cruel and unusual? They say yes, and part of the cruelty of it is the anxiety it produces.
Yes.
Yeah.
Ann Taylor says that I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years. And the way Idaho is doing it right now isn't really working. It's not a realistic option, I think, to have him sit on death row and say Idaho is going to figure out how to kill you at some point in the future in a way that isn't cruel and unusual and a violation of rights. Taylor noted that the primary method of execution in the state was lethal injection, but the state also approved the use of the firing squad after experiencing difficulties obtaining the drugs needed to administer a lethal injection. She also argued that the firing squad has not been built yet. The prosecution argued that there could be more alternate methods of execution in the future. You don't know decades from now what an alternate might be. Maybe they'll have a better argument decades from now on the method of execution, because maybe there will be another method, Deputy Attorney General Nye said. Nye said that objections to the methods of execution should not take the death penalty out of consideration. You don't get to, at the beginning, short-circuit the whole thing and say death is off the table because the current method is unconstitutional, Nye said. The defense also argued that the Idaho legislation does not do a sufficient job of narrowing down who is eligible for the death penalty. Instead of being a situation where the worst of the worst are being charged with the death penalty, everyone falls within that category. Eliza Massuth, another attorney for Kohberger, said, and that cannot be remedied by anyone else other than the legislature, because that is their duty. And if there's no narrowing and it's arbitrary, there's a basis for this court to strike down the death penalty. So these are some of their arguments. However, Mike, one of the reasons not perhaps to be pro-death penalty is because people that are convicted and receive the death penalty usually will not get it for 20 or 30 years. But there are endless appeals, which the state entertains. And it goes on for years. That's why there's a thing called death row. And there are people languishing on death row for 20 and 30 years before the courts fully decide to implement the penalty that they received after they were found guilty. Your thoughts?
Bill, the idea that you could execute someone with the death penalty quickly, that idea is long gone. In the 70s, when the Supreme Court approved Georgia's revised statute on the death penalty, Georgia had really done a great job. They had enhanced the definitiveness of who the death penalty would be applied to. They got rid of the arbitrariness by having the second vote of the jury. They also included, to make it really respectful of everyone's constitutional rights, they included automatic appeals that could be made on behalf of the defendant, so that therefore everything with the trial court's decision, the jury's decision about guilt or innocence, the decision about the death penalty being applied to them by the jury, all of that would be automatically appealed to make sure that at least one level higher court, an appellate court, and maybe also the state Supreme Court, would be able to take a look at it and determine whether or not that person got a fair trial, a fair hearing, the death penalty is constitutional, basically get their due process. So that's been the law of the land for almost 50 years now. And every state that has a death penalty, they do it almost the same exact way. And so therefore, the idea that, Ann Taylor would complain about the time frame that it takes to have someone on death row, that's something she would have advocated for 50 years ago if she had been practicing 50 years ago, to have all these safeguards. So you can't argue for these safeguards and say at the same time, oh, it's cruel and unusual because of the safeguards. She's doing the best she can. But these arguments, they're specious. And I don't think the judge is going to really give her much play with any of this.
Brenda G from the chat, just like the anxiety has caused the families of the victims. Yeah.
That's right.
Talk about anxiety. Exactly. Nina Chandra, I don't know how criminal defense lawyers sleep at night when fighting for people like Kohberger. Candace Breeze, I seem more fixated on the lawfulness of death in USA than this woman. Well, she has a job to do. Pauline Buckles, speaking of short-circuiting, how about the chair? The chair has been off the table. I didn't mean that to be a joke. It turned out to be a little double entendre. The chair has been off the table for many, many years because it was ruled as cruel and unusual punishment. I mean, no matter what way they come about or they invent to take someone's life and vis-a-vis the death penalty, I think it's always going to be ruled as it's cruel and unusual because it's killing somebody. But that's still on the books in, I believe it's 27 states, Mike?
That's correct. 27 states.
So 27 states have the death penalty. Years ago, New York used to have it, and then New York took it off the table. So it's Sing Sing. They used to call the chair at Sing Sing Old Sparky. And that was where they actually did use the electric chair. But it's been, I don't know what year the electric chair was taken off the table, but they have something in Idaho that seems even more barbaric, and that's a firing squad. And in Idaho, a firing squad is perfectly legal to implicate or to give the death penalty to the convicted felon. Mike.
Yeah, Billy, the Supreme Court of the United States has looked at all of these methods of execution: hanging, the firing squad, lethal injection, the electric chair, and they've determined so far that so long as their methods are in place and it's certain that the person will die as quickly as possible, painlessly as possible, then it wouldn't be cruel and unusual. In the case of a firing squad, back in the 1870s, back in 1879, the Supreme Court looked at a case called Wilkerson versus Utah. and it was the first case that the Supreme Court ever looked at that validated a method of execution. And they said killing someone by a firing squad is perfectly constitutional. Now, that was the 1870s, but now you jump to the 1970s, you had Gary Gilmore being shot to death with a firing squad. And the Supreme Court back in the 70s looked at that and it passed constitutional muster. So, this is an emotional issue, and people are either for it or against it, and it's really difficult to get somebody in between. But she can make all the arguments she wants, but the firing squad is, if she challenges it, it probably will not be successful.
MS in the chat, does the defense really believe that Bryan Kohberger is innocent? MS, I don't know what they think. However, I know that many, many people that follow this case and follow the Kohberger case, the Idaho murder of the four young students, many people think he's innocent. And I was sort of baffled by that. And I had to answer up to a lot of, in fact, when we had Matt Murphy on, that great LA County, Orange County district attorney who's tried, he's 65-0, trying high profile murders. When he said the evidence against Kohberger is overwhelming, you would not believe how he was attacked in the chat. I was like, and people were like attacked not in a nice way, like acting like one of the premier prosecutors in the nation. Oh, he doesn't know what he's talking about. Yeah, I guess not. He was 65-0 as a homicide prosecutor, and he has no idea what he's doing. So you're right. He is. So many people believe that Kohberger is innocent. And we could go through the reasons, but people say, oh, it was a party house. There was a drug house. There was a drug deal gone bad. There's all of these shady little reasons that have no evidence that they are true. But people are putting them out there, these conspiracy theories, if you will, Mike.
Yeah, the Matt Murphy, you should take him at his word. He knows what he's talking about. He's done, all of these homicide cases. He's done manslaughter pleas. He's done all of these. He's had several hundred cases, probably from start to finish, that have pled out and things like that. So he knows what he's talking about. And he mentioned DNA. Bryan Kohberger's DNA was found at the scene. They made sure, and after they arrested him in Pennsylvania, they took a buccal swab, and it matched to like 1 quadrillionth of a chance, a number that doesn't even exist. That's a theoretical number. That's more than the people that live in the entire world. That's how accurate that DNA test was. And so therefore, if you think Bryan Kohberger was framed, then you got to figure that the police knew it was Bryan Kohberger, somehow got his DNA without him knowing about it, before the murders, and then when maybe the police murdered the 4 students, put his DNA on the knife sheath, and then matched it later on. It seems like really fanciful, but I guess there are people out there that just don't want to believe that a person could kill 4 innocent young people, 20 to 21, by stabbing them to death within, say, 10 minutes. They just cannot fathom that evil can act that way. And, that's their opinion, but the case will go to trial in about 8.5 months, 9 months, and we'll see what else they have. We haven't heard a lot of information. We haven't seen the crime scene photographs. We haven't seen all the electronic information. So maybe people will feel a little bit better about it when they see all the other information that they have against Kohberger.
Mike, and I don't want to just get on this because we may cover this Tuesday night when we go on. We're going to do a show on the 2-year anniversary of this. And I hate to use the word anniversary because anniversary is usually a happy event. And this is a 2-year, so to commemorate when this occurred, 2 years on the November 13th. But there's other evidence vis-a-vis him showing up at the house at 9 o'clock in the morning to see what was going on. I mean, that is a classic response of a serial killer does that. And I'm not saying he's a serial killer, but a killer going back to admire his handiwork as to what occurred. The other thing is his conduct in throwing his garbage in his neighbor's garbage cans, cleaning his car with alcohol and all of all those things are, Mike, I'll get to use your famous expression,
Consciousness.
of guilt.
Thank you.
He's trying to cover it up, and that's consciousness of guilt. Claudia Lenzer-Stoffer, thank you for the 5-pound super sticker. What is with the rights of the victims that were brutally murdered? Why are the rights of a murder count more than theirs? I don't understand. Claudia, because our system is a confrontational system in which the prosecution has to prove guilt beyond a reasonable doubt. The defense doesn't have to prove innocence. They don't have to prove anything. All they have to do is to create doubt so that the prosecution fails in their job of proving the case beyond a reasonable doubt. And that word reasonable is defined in the criminal justice code and the criminal procedure law. So reasonable. So what is reasonable? Like beyond a reasonable doubt. And Mike, I think that you probably have the term reasonable memorized, the definition. Could you regurgitate that for us?
Well, reasonable doesn't mean that beyond all doubt. You may have a juror looking at this case may say, yeah, there's been a lot of information that points to Bryan Kohberger's, guilt in this case, and a horrible case it is. But, there was on the defense, they raised a few points about, well, maybe something, the first female, they identified her by initials, DM, I think it was, I can't remember, who said
Dylan Mortensen.
Thank you, DM, right, Dylan Mortensen, that she saw a figure that was about 6 feet tall, slim build, with bushy eyebrows. Now, did Dylan Mortensen, pick him out of a lineup? No, she saw this figure, shadowy figure, like 4:25 in the morning. She was exhausted. They probably had been partying a lot. She heard noises. She looks out the door and she sees a strange guy walking by, and he's got a mask on. All she could see is his eyes. Now, we believe that circumstantial evidence, knowing with everything else that is probably Bryan Kohberger. But is it possible that there may be some doubt in someone's mind as to whether or not she actually saw him? Could it have been someone else? There's always a little bit of doubt, but taking everything into account after the trial is over, even if you have a tiny little doubt here or there, is that doubt overwhelmed by all the other information that you got? Can you say with good conscience that you believe beyond any sort of real reasonable doubt, not picayune, reasonable doubt that he committed the crime? You could vote with a clear conscience to convict him. If you believe that there actually is some reasonable doubt that he may not have been there, that they got the wrong guy, then you should vote your conscience and acquit him. So reasonable doubt, it's a word that can mean just about anything, but and that's what the defense really wants, is always going to tell all the jurors, like, reasonableness. Do you really feel that there is some doubt? If you feel that there's some reasonable doubt, then you have to quit him. And reasonable can be different to different people. You and I could be sitting on a jury right next to each other, watching the entire thing, and I might come to a different conclusion than you based on what I feel is reasonable. So it's really difficult to actually define reasonable, but it's an individual kind of standard. But is there enough evidence that even if not every single tiny little fact is nailed down, have all the important facts that show that the corpus delicti was committed, or all the facets of the crime were committed by the defendant? I mean,
and guys, you just used the term corpus delicti. That does not mean the body. That means the body of the crime.
That's correct.
See, I learned something when I was a criminal justice professor. You
I
know,
love Latin, right? Don't you love those Latin
just
phrases?
electi, because it sounds like it means the body, and what it doesn't. It means the body of the crime. Mary Buckles from the chat, very interesting. I met and talked with Matt Murphy last week on the crime cruise, and he looked me in the eye and said that he was guilty. And I'm sure you're referring to Bryan Kohberger. Well, we had him on the show, and he said the very same thing. And he has prosecuted some of the highest and profile and most difficult cases. Claudia Lanza Stuffer, again, thank you for £2 super sticker. Kohberger was bullied at school for years by girls. Well, Claudia, that may be a motive, but in our system, the prosecutor does not have to prove motive. It's helpful to know the motive, but that's not one of the things that they have to prove. Let me go to Crime Fix here. Play a little of this.
When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person.
Bryan Kohberger's lawyers are pulling out all of the stops as they try to convince the new judge in his case to remove the death penalty as a possible punishment, and the state is pushing back.
So there really is just no evidence whatsoever to suggest that Idaho can't do that, and certainly not that it can't do this decades from now.
Welcome to Crime Fix. I'm Anjanette Levy. Bryan Kohberger was back in court in Ada County, Idaho, where he is scheduled to go on trial next August for the murders of 4 University of Idaho students. Kohberger won his fight to move the trial out of Latah County to Ada County, which is in the Boise, Idaho area. He said he couldn't get a fair shake in Latah County. Now Kohberger is in a new county with a new judge. His name is Stephen Hippler, and he seems like a no-nonsense judge. And the big issue on the table right now is whether the jury will be asked to consider the death penalty when Kohberger's trial starts. Prosecutors are seeking the death penalty against Kohberger for the murders of Maddie Mogen, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle. The 4 college students were stabbed to death, some as they slept, in the home on King Road off campus nearly 2 years ago. It's a horrific crime that shook the small, tight-knit town of Moscow, Idaho. But Kohberger is taking the case to trial, and his attorneys have said he is innocent. Kohberger argues the death penalty violates the 8th Amendment. It's cruel and unusual punishment, particularly lethal injection. But in Idaho, it's worse, Kohberger argues, because if the Department of Corrections can't get the drugs used to carry out an execution, the firing squad is now an option. The family of Kaylee Gonsalves specifically supports the use of the firing squad. Her family has been vocal about that. To help make his argument, Kohberger enlisted the help of Dr. Barbara Wolf. She's a forensic pathologist who analyzed evidence in O.J. Simpson's double homicide case in the 1990s. Wolf had signed an affidavit for Kohbergers Defense saying death by firing squad could be painful, and it could cause a lot of suffering. The affidavit says the intended target in an execution by firing squad is the heart of the condemned individual. Assuming that the shooters are competent marksmen, the condemned individual will be shot in the chest. The bullet will cause injuries to the heart, large blood vessels, bones, and possibly the lungs. The mechanism of death will be shock resulting from bleeding due to damage to these organs. Dr. Wolf said if the shooter doesn't strike the heart or a large blood vessel, the condemned person may slowly bleed to death. The defense wanted Dr. Wolf to testify, but Judge Hippler said, "Nah, I have her affidavit. I don't need to hear her testimony." I want to tell you about the sponsor of today's.
So there's some proof there, Mike, that this judge is not playing games. First of all, why is Ann Taylor reinventing the wheel? You know, there's been other arguments that the death penalty is cruel and unusual, and they've always been turned down. So why is she reinventing the wheel and doing this again? He's not going to listen to it. The higher courts have already determined, yes, it's constitutional in this state.
You know, Bill, it's a fait accompli, but she's got to do what she's got to do to zealously advocate for him. She's doing the best she can. You know, she was handed this case with all of the forensic information, all of the electronic information, DNA, everything. You got it. And she's doing the best she can. She's swimming, you know, it's like swimming upstream. She was against the tide. It's really difficult. She's got to make these arguments knowing that there's a 99.9% certainty that this judge is going to throw out, throw out her motion, deny her motion, and they're going to go ahead with the trial. Because as he has pointed out to her, and as the district attorney has pointed out to her, the methods of execution that they use in Idaho have all passed constitutional muster from the state legislature. I'm sorry, the state Supreme Court of Idaho and the United States Supreme Court. All states that have these methods of execution are all the same. So they do the same like choices that they have. If they can't get the drugs because there's maybe the pharmaceutical company won't sell them, they have to use some other method of execution. So they always have to have two available. And in Idaho and out west, like in Utah, they've always had the firing squad. So, yeah, she could, have an affidavit and talk about how painful it is to get shot to death. But, also people can die pretty much instantly if you shoot them in the heart. And I think in Idaho, I'm sorry, I think it's in, Idaho, yeah, they have a firing squad. I think it is actually a mechanical firing squad where they aim rifles at the person's heart, and there's not, men with rifles.
Well, there's not a human being actually pulling the trigger.
Right. It's mechanical. So
Yeah.
I don't think that really is applicable anyway. But she's doing her part. She's doing the best she can.
Folks, this is Police Off the Cuff, real crime stories. If you like real crime, true crime from a police perspective, you're in the right place. And if you're not subscribed, right on the screen, just hit that red button, subscribe button. Become part of the Police Off the Cuff Real Crime Stories family. If you want to contribute to us financially, we have a Patreon with 4 different levels, and we have a YouTube channel membership with 5 different levels. And you could become a member of the Police Off the Cuff YouTube family. Let me go back to Ann Taylor, see what she says to the court.
Lawyer Ann Taylor said Idaho doesn't have a method of execution currently. She was quickly corrected.
We think that the court ought to strike the death penalty in this case and not allow the case to go forward as a death penalty case because Idaho does not have a current means of executing anybody. When somebody sits on death row and there's no real means of executing them, that is dehumanizing to that person. That's similar.
Say there's no means under Idaho law, the method of execution is lethal injection, and if unavailable, then the firing squad. You rely significantly on the idea that lethal injection is not available based upon the quote-unquote botched execution of Mr. Creech. It seems to me that was a particularized incident wherein Mr. Creech, the execution really hadn't even begun yet in the sense that they couldn't locate a vein. I don't see how that issue is universal.
I would agree that Mr. Creech's, the situation that happened to him was unique to him. I don't think he's the only person that has ever had that happen. Not in the state of Idaho, but I think that that's happened before when the means of execution couldn't be employed at the time.
Thomas Creech is a serial killer whose execution was botched earlier this year. His execution is currently on hold. Ann Taylor then discussed the option of using the firing squad as an alternative to lethal injection.
The firing squad ended up on the books because of the difficulty obtaining the drugs to kill somebody. That's why the firing squad came back. Idaho.
Now, I just want to mention something. The difficulty in obtaining the drugs is because the drug companies don't want their drugs to be used as the instrument of death for the convicted. And I don't know if that's because of potential legal issues that they can be sued and they be fighting this stuff in court forever, or is that a moral issue? What are your thoughts, Mike?
Bill, I think it's more the former rather than the latter. I think it's you're right. If the drugs may cause in the future may cause a prolonged death that may be classified as agonizing, painful, beyond reasonableness, that the drug companies may be open to some sort of a lawsuit by the family and the estate of the decedent. That's possible. What they would really want would be cover for any civil liability where the state would indemnify them. Maybe that is what they're really looking for. But I think you're right. They don't want to be associated with it because this could be a loser for them monetarily at some point in the future.
So you can imagine the amount of litigation, the amount of legal precedents that have been set in regards to the death penalty throughout this country in the 27 states that still have it. It's almost like, in one way, I'm pro-death penalty. In another way, intellectually, I realize to execute someone probably costs millions and millions and millions of dollars because it's in lawyers' fees and court time, because there's unending appeals where people can sit on death row for 30 years before, and then sometimes it's totally reversed, and it's reversed. We change your sentence to life without parole. But one of the things we've learned in New York City is that life without parole doesn't mean that. We've seen that with cop killers who got life without parole 30, 40 years ago and are now getting paroled with impunity by the state. And that drives the police unions and the families, the survivors of the murdered cops, who are seeing the guys who murdered their father, their brother, their cousin, their husband, their wife. They're seeing the killer paroled. And so what does life without parole really mean if it doesn't mean that? What does it mean, Mike?
Billy, that's the problem, because as you say, if you have a death penalty case and the person and the jury's deciding, they've already convicted the person, now they're deciding whether the person gets the death penalty, or if they can't really agree on that, then it's an automatic life without possibility of parole. Now you say, and like in New York, you hear about life without possibility of parole, and people are thinking it's actually natural life. We just saw this very recently in the Susan Smith case down in South Carolina. If anybody remembers, back in the 90s, she put her two kids in the back seat of their car and put the car into neutral and let it drive down a boat ramp, and the kids drowned to death. And then she could be with her new boyfriend. At her trial, she was found guilty of double murder of the two kids, aggravating circumstances. She was sentenced, but the jury, they convicted her, but they did not feel it proper to put her to death, and they voted for life beyond without possibility of parole. However, she is coming up for parole, and it seems rather strange because the jury wasn't aware when they sentenced her to life without possibility of parole, when they voted for life without possibility of parole, thinking she would be there for natural life, that she would actually ever come up for parole. And so it's kind of a weird switch, bait and switch kind of routine with juries. If it's life without possibility of parole, it has to be without possibility of parole. It has to be certain that this person will spend natural life behind bars, or else you're misleading the public, and the jurors. The law has to be definite death, definite life without possibility of parole. It can't be something in between, like you're describing in New York here or in South Carolina. That is misleading the public too. It's misleading, and it's a disservice to everyone.
Mike, just an aside here that has nothing to do with this case. I was contacted by Homicide New York, the show that Dick Wolf does that's on Netflix. And they recently did a bunch of cases from New York City. And in fact, just about every detective and sergeant and lieutenant that was on that show I worked with. And I was called, and they want to do a case that I worked on in 2000. And I'm not going to go into the whole case, just that it was about this young Asian girl who was 17. And she and her 20-year-old boyfriend murdered both her parents and threw them in the East River. And the Asian girl, her name was Connie Lung, she's out. And she didn't do her 30 years. She's got 30 to life. She got out a couple of years ago. However, her boyfriend, his name was Eric Louisant, He's still in prison. He's got 6 more years. Well, till he got 2 consecutive 15 to lifes. So he will probably get paroled also because she's been paroled. And so the sentence never means what it says. 30 to life, it didn't mean that for her. She got out a couple of years ago. And so what did she do? Maybe she did 22, 23 years. So it never means that. Just like the death penalty is something that perhaps should be taken off the books because it's just so expensive and time consuming to implement, because the courts, the Legal Aid Society, and many people that are anti-death penalty, they fight it forever as if money is no option and obstacle, I should say, not no option, no obstacle, because it's being paid for by the taxpayers. Claudia Lanza-Stouffer, thank you again for a £5 super sticker. Kohberger were near around there at the time of the murder. His phone connected on the Wi-Fi of the student house. Am I right? Yes, you are right. He was. That's when he, during these murders, going to and from the house, he had turned his phone off. But when he went back, he turned the phone back on, and his phone was pinging right on the site of where the house was. So yeah, no, you're absolutely, Claudia, 100% correct. Robert P. in the chat, electric chair still legal in Alabama, Arizona, Florida, Kentucky, Louisiana, South Carolina, and Tennessee. Well, thank you for that information. I wasn't aware who still has it on the books. Brian Oblivion. Yes, the state of Iowa is going to execute an innocent man on flimsy circumstantial evidence. It's Idaho, not Iowa, right? He's in Boise, Idaho. But Brian, there's tons of evidence. There's not many people say that to me, and I'm baffled about it. But many people think that, and you can think whatever you want. And this case will be going to trial, and we'll see. My cat's name is Karen. They just convicted Chad Daybell to the death penalty in Idaho earlier this year. Candace Breeze, first of all, you don't get to have on hand as a defendant to handle evidences. I'm not sure what you're referring to, Candace. Let's see. Holly, inhumane, isn't he on trial for murder? Yes, he is. Emily Parkinson, if he's found guilty, then I don't give a rat's patootie about his mental anguish over the death penalty. The monster didn't give a thought to those 4 kids he took the lives of. Emily, you're 100% preaching to the choir, as we say. Shad Ranish, his phone was off. They saw his motions from multiple car cameras, I think. Shad, his phone was off much of the time, but he turned it back on when he came back to the house. And they actually were able to track him coming back to the house I think it was at about 9 o'clock in the morning. Robert P., thank you for the $2 super sticker. Guys, this case is just so off the charts interesting. And, and of course, everyone always wants to know the why. Why did he do this? What was his motive? And, we've heard so many invented motives. We don't know the specific motive. But they were looking for a nexus between Bryan Kohberger and one of the young ladies who was murdered. They kept saying that he may have had some connection to Madison Mogen. And we don't know if that is true at all. Is there text messages? Is there emails? Is there any of those things? If there is, the prosecution, the police are keeping it very close to the vest and haven't released it yet. So we haven't found out about it. But I guarantee you there is tons of evidence in this case, some of it that we don't know about. And everyone thinks that everything that the prosecution has been released. And I would bet that they pull a cat out of the bag. And I'm sorry for the girl my cat's name is Karen, to use that expression. They're going to pull a cat out of the bag there, and which may be like smoking gun-like evidence. Mike, your thoughts?
Bill, if there's anything that people should know is that you don't have really a lot of privacy in your laptop and in your phone. We live our lives using those two electronic instruments. And if they've got his phone and they've got his laptop, or a laptop that maybe he signed into to use on the University of Washington, where he was only there one semester, so it was probably limited. And they'll look at all of the cell phones and all of the laptops from all of the poor victims. And if there's a connection, then boom, that is good evidence that there was an attempt to make contact. People have come to the idea that he was enamored with one of the girls, and that he was fixated on her, and that he may have tried to get in contact with her. Perhaps he'd been seen in the area driving around trying to figure out where she lived. It's not a big area. Not a lot. It's not like New York City, Times Square kind of crowds. So this case has been hermetically sealed by the police, the FBI, the Idaho State Police. Nobody's talking. We'll find out more. But if they've got anything that connects him to, Gonzalez or Knodel or anyone of the Idaho 4, then they have it, but they're not releasing it. That'll be all given to to the public at trial when they do testimony. But I can pretty much guarantee, I'd bet my paycheck, the whole reason why he did what he did was he was probably rejected by one of those girls. That's what I'm thinking. I would bet my paycheck on that.
I think there's a possibility of that, but we don't know that, so we can't. People throwing out all kinds of theories. Emily Parkinson, welcome to the Police Off the Cuff family. Thank you so much for becoming a member. Thank you for joining. On Tuesday, we're going to do a show on this on the 2-year to commemorate the 13th of November. We're going to do it the day before on the 12th. And I haven't reached out to Matt Murphy yet, and I don't know what I'm waiting for. I'll do it after the show today, and I'll see if he'd like to come on. I know Dr. Debbie Goodman has texted me, and she wants to come on and do a show about this. So there's a lot of people thinking about this, and this case has touched many people across the nation and across this world because of the horror, and also the youth of the victims. Emily Parkson gifted one Police Off the Cuff membership. Emily, thank you so much for your generosity, and to the person who receives that, welcome, congratulations, and you have to thank. Thank you so much. There's so many questions that we have, but tonight we really wanted to just concentrate on the court hearing in regards to the death penalty, the ways that they can serve the death penalty up.
Brings it back in 2023. They bring it back because it's not reliable to believe they're always going to be able to get the chemicals to execute somebody. And that's the real problem here. The firing squad hasn't been funded well enough to be built.
I think they're building it right now, as I recall from the media, at least, that the construction's actually underway. But I may be wrong about that.
Well, I haven't talked to the director of the Department of Corrections, and that's probably who I would take my word from if that's actually happening right now. I think there's some additional problems with the firing squad, though. I think there's some problems with the way our statute lays it out, too.
Judge Hippler made a point. First, Kohberger would have to be actually convicted for a jury to consider the death penalty in the first place. Second, if the jury chose death as an option, the appeals process would take decades.
But the reality is if he is convicted, we know it's going to be a decade plus before that sentence would be carried out. And who knows what the methods may be then. And, I think that part of why you're saying you shouldn't have to comply with Buckwell, but it seems to me that same rationale then applies to why I should even consider this motion. Why wouldn't we wait until that time frame to see what the current methods are? Who knows what technologically is going to be available at that time?
I definitely hear what the court's saying. I would come back to saying that we're not in the place where he's challenging the methods that's about to be employed. We are decades away from that, if that were to even happen. But what I'm saying is, I don't believe that our Constitution allows for us to move forward and make him sit on death row for years and years and years. And the way Idaho's doing it right now isn't really working. It's not a realistic option.
The defense is always against the death penalty. This is their job, and most defense attorneys are just morally and philosophically opposed to the death penalty. It was then the prosecution's turn to argue.
What I'm hearing from the defense is they just have this kind of like vague Eighth Amendment assertion of maybe it's kind of the anxiety, but kind of not knowing how you're going to be executed. Well, that's not how the law works. There's an established framework of how you can make an Eighth Amendment method of execution claim. And Bucklew, the court specifically said, I'm quoting here, identifying an available alternative is a requirement of all, and all is emphasized in the decision, all Eighth Amendment methods of execution claims. You can't get around that by just saying, well, but I'm making a slightly different kind of claim. It's not a method of execution, it's a means of execution claim. That just doesn't work. That's not how the law operates.
The prosecution and Judge Hippler noted that there is case law in Idaho that allows a condemned person to actually choose a method of execution.
They haven't even suggested, even today in argument, what a proper alternative would be, which also gets back to the ripeness issue, which is we don't know decades from now what an alternative might be. Maybe they'll have a better argument decades from now on the method of execution because maybe there will be a better method. And that gets to the final point I want to bring up, which is the remedy here. They're asking that the death penalty be struck because these methods are unconstitutional, but that's not how it works. If you show that one method is unconstitutional, part of the reason you have to present a viable, readily implemented alternative is so that the state can then use that method for the execution. You don't get to, at the beginning, short circuit the whole thing and say death is off the table because the current method is unconstitutional. As I said before, the method could change. And so if they came in and they had evidence and they could show that there was another method that's not lethal injection, that's not firing squad, that severely or significantly reduces the pain, and it's readily implemented, the answer isn't to strike it, the death penalty completely. It's to say, okay, you can move forward with the trial. We can see if he's sentenced to death, but you can't use those two methods to do it.
I want to bring in Michael Lasher. He is a death penalty.
So, interesting points of view. Sandra Preston from the chat, I wanted to just read this because they thought the same on Richard Allen. Here is my huge concern. Who are you people to convict someone? This is the United States of America, and you are innocent until proven guilty. Sandra, you're 100% right. However, you're right. This is the United States of America, and people are allowed to give their opinion without the addendum, he's innocent until proven guilty. If that's their opinion, that's fine. No one is getting hurt by their opinion. So you're 100% right, though. People in our system are innocent to proven guilty. Again, we all have the right to voice our opinions. Michelle from the chat, DM, who's Dylan Mortensen, and the eyebrows, that's BS. She never mentioned eyes. You see them if you could see eyebrows, unless he was leaving the scene of a mass murder with his eyes closed. Michelle, she did mention bushy eyebrows. And one of the things was, we all remember the COVID masks. He had a mask up covering his nose. So that covered much of his face. So I had raised this question many times. Can you identify someone when they have a mask on? There are other identifiers in your face. For example, their eyes, like you mentioned, and the eyebrows and the forehead, for example. Can you make a proper identification? I don't know. Eyewitness identification is always under question anyway, even when someone gets to see the person's whole face. In this instance, she saw the whole person, except his face was covered with what was described as a COVID mask. And she described he was tall and thin with like an athletic type build with bushy eyebrows. That was pretty much the description she gave. So will she be useful as a witness? And I don't want to get too deep into the case. What we really are talking about is the argument against the death penalty here. And to tell you the truth, I somewhat think that they put the horse before the cart rather than vice versa, because I don't think this was the defense's, I don't think this was their fight in a way. Because let's take the case, and then if he gets found guilty, isn't that the time to argue whether the death penalty is appropriate and to try to argue these things? But to argue it right now, to me, seems like a waste of time and money. Mike.
Bill, you're right. The best time to argue is if he is found guilty and if the jury imposes the death penalty, votes for the death penalty, and the judge imposes it. So we have a couple of steps. Putting the cart before the horse, it means that this issue, the issue of the constitutionality of the death penalty and the method by which it may be imposed, it's not ripe yet. It's not ready for judicial review by the judge. That's what the prosecutor is saying. We'll discuss this maybe later on, perhaps not even until decades from now. You don't do it now. The discretion to charge somebody with capital murder, murder one, to make it a death penalty case rests solely with the district attorney, and that is the law of the land in every state that has a death penalty. And it is not up to. I've never seen this before, where a defense attorney could assert that the death penalty, that the prosecution could not try this case as a death penalty case because the death penalty was unconstitutional. At this point, it's not up for debate. It's not ripe. It will become ripe later on after certain conditions precedent have been met. He's convicted. The jury decides not to impose life behind bars. The jury decides to vote for a capital punishment, the death penalty, and then it is imposed by the judge. Those three things have to happen before this discussion about the constitutionality of Idaho's death penalty occurs. So you're right, putting the cart way before the horse, way before the horse.
Although, Mike, one argument for why the defense could be allowed to do this is because there has to be a death penalty jury if, in fact, they are going for the death penalty, which they have indicated, yes, they are. Mm-hmm. So the jury has to be jurors who are okay with the death penalty, who are pro-death penalty. Right. So anyone who is against the death penalty will not be chosen for this jury. So I think that needs to be pointed out. Anders Gustafsson, I think the prosecution has a good case. Idaho, especially compared with Delphi, Kohberger's alibi is that he was stargazing in the area where the girl's house was situated. Dana Hodgian, the judge is not going to agree with the defense on the death penalty. No, he's not. And he sort of made that pretty damn clear. If he would have allowed any of their arguments, then it would have been like, yeah, you got a good argument. But as Mike and I said, we think they're arguing something that is not really in the purview of this judge. This is going to go to higher courts, and let's take this to trial. Like Mike, you said, this is in the purview of the prosecutor who has chosen to go for the death penalty. Now, if there is a conviction, I think that's the time to argue it, not right now. At least that's my thoughts, and I could be wrong.
No, you're right. You're right. There's a time and place for every argument when the issue is ripe to be argued and it's time for it to be argued. There's no way. This is unheard of that a defense attorney could assert a right to challenge the death penalty, have it thrown out before a death penalty case, before a murder one case, capital murder case. That's never been done in America before. That is ridiculous because that would eviscerate the law. The law is written, allows the prosecutor to choose the death penalty if certain factors are met. And certain factors are definitely met in this case. So it's in their discretion to do this. She's trying her best. I mean, she's doing the best she can. She's zealously advocating for Kohberger. He's got a great defense team. She's doing all she can. She has to, under the rules of ethics. But she knows where this is going to end. She knows he's going to deny her motion.
Mike, I'm not arguing or disparaging the competency of Ann Taylor. I think she's probably an excellent attorney.
She is.
She was a former Olathe County district attorney or assistant district attorney under Bill Thompson. So we know she's experienced. We know she's qualified. We know she's good. And she's trying everything to give a viable and a good and a competent defense to Kohberger. Daryl Hicks, playing it like a loser. Loser moves. Judges know when a party is guilty by the move she makes. It pulls some pressure off the innocent party. Well, I don't know if I agree with you, Daryl, but I thought I'd read what you wrote. TNT, I think there might be some additional evidence that showed up. QD, they want the DP off the table before he makes a plea. Yeah, I don't see any indication that, and if he was going to make a plea, it would be after the judge rules on all of these arguments that Ann Taylor is making. Emily Parkinson, this is the only channel that doesn't automatically renew my membership. Let me know it's time to renew. I don't know what to tell you, Emily. I'm not, I'm not great at the computer. So many things, like especially Patreon and all those things, I just pray that it all works right so that I don't have to go in with a wrench and everything and fix things, because how I've even come this far with my computer skills to be able to do this show is amazing. And that's all I'm going to say. I'm not going to, but I appreciate you. Thank you so much. Helen from the chat, BK should be made to wear the jail clothes, not a suit for hearings. I get it for trial, but not for a hearing, special treatment. Well, Helen, yeah, the defense requested that he not have to wear the jumpsuit, that he could wear business attire. And I think that was agreed. They would let him do that. And I think that they feel that makes the jury feel you're looking more like a human being, not someone in a prison or jail jumpsuit that leads you to believe that they're a criminal, And so for the defense, they would definitely make that request that he doesn't have to wear that jail jumpsuit and he could dress in business attire. That's what we used to call it on the police department. Wear business attire. Oh, you mean my Robert Hall suit? Remember Robert Hall? You got to be old to remember that place. Anyway, folks, that's what we wanted to present to you today, that the hearing in regards to the potential of the death penalty. It seems as though, based on the judge's body language and based on some of the things he said, that he's not buying any of the arguments that Ann Taylor presented. And it seems as if he knows precedent has been set on previous cases. So to change any of this precedent on Ann Taylor's arguments really doesn't hold any water. Mike, your final thoughts.
Final thoughts is that there's going to be a few more motions before this trial before the trial next summer. So we'll bring you up to date on any of those things that occur. But just think about it. As we hear more about the evidence when it comes to trial, we'll be forming our judgments. But as law enforcement officers, we see this differently than a lot of people do. So we may have more faith in the system than other people, but pray for justice for everyone. Kohberger deserves justice. Those 4 innocent children deserve justice, and the public deserves justice. And hopefully at the end of everything next summer, we will have justice. Hopefully.
Absolutely. Before I sign off, I just want to always shout out to these 4 young students who lost their lives almost 2 years ago: Ethan Chapin, Madison Mogan, Zana Knodel, and Kaylee Gonzalez. We pray for their families. We pray for their souls. And I want to thank everyone for tuning in today. I'm Bill Cannon from Police Off the Cuff Real Crime Stories. On behalf of myself and Professor Mike Geary, thanks for tuning in. Have a great day, and God bless everyone. One episode, just ain't enough.